Okay, well, we're going to get started. I'd like to welcome everyone to the Nashville Bar Association Town Hall meeting with Judge Frank Clement of the Tennessee Court of Appeals. Judge Clement, thank you very much for sharing your time with our members today to talk about changing procedures in our courts because of the COVID-19 pandemic.
Well, it's always a pleasure to be with you, Laura, and anything I can do to help the Nashville Bar Association and our members, I'm thrilled to participate.
Thank you so much. And we'll get started with a broad question about what, if any, procedures have changed in the Court of Appeals because of the pandemic, and are those changes still in effect right now?
Very good question. The changes that the Supreme Court enacted through approximately 3 Supreme Court orders in March are no longer in effect in reference to the appellate courts. Particularly, the most recent order expressly exempts the continuances and deadline delays, exempts the rules of appellate procedure and the appellate courts. And so if you have an appellate practice, it's very important for you to abide by the deadlines that were in effect last year and the year before and the year before that. So don't be counting on a continuance. The last one really expired April 30. The biggest change is that the Court of Appeals in the last 2 weeks has heard 11 oral arguments by video conference. Chief Judge Sweeney, Presiding Judge Steve Stafford from the Western Section, and I heard 2 of 3 cases on Friday, May the 1st. Judge Andy Bennett substituted for me on 1 of those 3 cases, and all 3 of those went well. Then on the following Tuesday and Wednesday, the 4 judges in the middle section, we heard 8 more cases, 2 on Tuesday morning, 2 on Tuesday afternoon, 2 on Wednesday morning, 2 on Wednesday afternoon, and all those also went very well. Occasionally, someone's voice would come across faster than their lips moving, but we never had any trouble understanding what the others said. For those 11 cases, we used WebEx. We are considering using Zoom, which you and I are doing right now. I'm not smart enough to know if one is technologically superior to the other. I do know we initially used WebEx because there had been some concern about Zoom bombing, but I understand Zoom is addressing that. And so we'll see which works. But today, I think it'll come out today or tomorrow, a docket for the first week of June will come out, and the Court of Appeals will hear 8 more cases by video conference in June.
And for the video conference oral arguments that you are hearing, are they being live streamed, or is there a way for members of the public to view them?
Very good question. As of this moment, they're not yet being live streamed, but we hope to go there. It's our intent for it to be a public event. All court activities are open to the public, but as of the last 2 weeks, they were in essence invitation only. In other words, you had to have the access numbers and passwords or what have you to sign in. We had some concern again that somebody might join in and be disruptive or have the lawnmower going in the backyard, or like the Supreme Court, the United States Supreme Court had last week, somebody flushed the toilet and everybody heard the sound. I thought that was appropriate. Maybe one of the lawyers didn't like the question, and that was his or her way of commenting on it. But we do hope to move to streamlining if we have to continue video conferencing. But in any event, the oral arguments are always being posted on the Administrative Office of the Court's website, so the arguments can be heard. Presently, there's about a 10-day, 14-day delay in that posting, but if we can go to live stream, we will. But people smarter than I will have to figure out that cyber technology. But we're open to it and want it to be an open hearing.
For lawyers who are participating in oral argument, do you have any suggestions on best practices? That could be anywhere from how to give the presentation itself by video or even clothing choices.
We judges wear our formal attire and our robes, and the lawyers are requested to dress as they would if they were in the courtroom. We're not going to refuse to hear someone if it's a man and he doesn't have on a coat and tie, for example, but we hope that to be a professional and respectful proceeding. I will say Jim Hibner, the clerk of the appellate courts, has been wonderful in that he calls the lawyers the day before to check on their connectivity, their ability to sign in. Apparently, some lawyers, I'm 70 years old and not the sharpest cyber sleuth in the world, but I'm able to sign in and do these types of things. Today I had Olivia help me because I wanted to make sure I didn't let you down. But I've signed in by myself with the court hearings, at least some of them. But what we have learned is it's important for the lawyer to be at a location where he or she has good connectivity, good internet service. That is a key component, because if they have poor service, then they might fall off the screen. Usually we can still hear their voice, but sometimes their face freezes. That doesn't minimize the importance of what they have to say, but having good connectivity is important.
Are you having any hearings in person right now?
The Court of Appeals, I do not believe so. I can't think of any that have been in person. We are, the judges, we are doing a lot of work by telephone conference. If we have some Rule 9 or Rule 10 applications, we'll have a panel entertain whether to grant them or whether to ask for an answer in the Rule 10. But we haven't had any in-person hearings that I am aware of in the last 2 months.
And it sounds like for the June oral arguments that are coming up, you're still planning to use video means for those as well. When do you anticipate going back to in-person court proceedings?
I don't know. The Knoxville judges, Chief Judge Sweeney particularly, is hopeful to return to in-person hearings, perhaps in June, but he has not yet made a decision. One of our concerns, at least the concern that was driving me, especially since our oral arguments were set for the first week of June and the other sections were going to hear court later in June, is that we don't have protocols for, let's say, screening people to see do they have a fever. We don't have the equipment to, or the personnel to wipe down the courtroom in between cases. There's a concern of you probably shouldn't use the same chemical to clean the microphone that you use to clean the glass on the table versus the walnut wood on the furniture. And so those concerns, uncertainties, and combined with the fact that some parties interested in a case might draw a bigger crowd than others, we were concerned that they would be gathering in what we call the Hall of Justice, the lobby. And there are other people working in the building whose health we're concerned about. And so for that reason, my colleagues in Middle Tennessee and I decided June would be a video conference, but we hope to get back to the courtroom.
What insight can you give us on what procedures you might put into place once in-court proceedings resume in terms of social distancing, masks, gloves, those temperature screenings that you mentioned?
Right. Those very things. Plus, we might say instead of everybody coming to court at 9 o'clock, we might say, Miss Baker, your case will start at 9 o'clock. And then we might say, your friend Liz Sitgreaves, Miss Sitgreaves, your case will start at 10. Please don't come more than 15 minutes prior to your hearing. Please don't arrive in the courthouse. And that way we are separating people, or at least we're endeavoring to do so. But right now, excuse me, before the pandemic, we expected all parties and attorneys to be in their seats in the courtroom before 9 o'clock. We think a way to open up the in-person hearings will be to stagger the cases, separate them by 45 minutes to an hour.
When there were extensions to deadlines in effect with regard to appellate cases, did any backlog develop? And if so, how are you handling that backlog?
It was modest backlog, but what we did is that I decided that we would hear some cases by video conference, or we would hear a certain number of cases by video conference. Those that we couldn't hear, I didn't want to keep them backing up and backing up. So I simply put down an order saying that your case will be heard on briefs. And if you believe that there's a compelling reason that for us to understand the issues and concerns you have, that you have to look us in the face, please file an affidavit and a memorandum of law to explain why due process and the interest of justice require that I see you in person to understand your legal arguments. One or two of those cases, the people filed an affidavit and a motion and a memorandum of law, and we granted it. And but the vast majority of them, we've said you have failed to establish a compelling reason why we won't understand your case based upon what you've stated in the briefs. And we certainly feel we have the authority to do that based upon the Supreme Court orders that says we can waive rules and requirements if we find that in the interest of justice. And it's important, particularly in termination of parental rights cases and custody cases and juvenile cases, where we have a mandate to move those cases forward. And so I think it makes sense to say they're going to be assigned on brief instead of delaying your oral argument for 2, 3, 4, 5 months. We don't know when it'll open up. I do hope it'll open up, but I think we should not believe that this is over. I don't believe it's over.
I want to invite members of our audience, if you have any questions for Judge Clement, if you'll use the Zoom group chat function at the bottom of your screen and send the message across either to me, or you can send it out to everyone. I'll be sure to ask Judge Clement your question. Judge Clement, on March 31st, the Tennessee Supreme Court issued an order clarifying its prior orders and specifically addressed appellate deadlines. Can you give us some background as to why that was necessary and what was going on that led to that order?
I don't know the specific motivation, but I think it was just a desire to clarify how that prior order affected the trial courts and the appellate courts, realizing that the appellate courts can do things without in-person hearings, whereas most trial courts, it can be done, but it's rare that you're not standing in front of and in the presence of the judge when the merits of your case are being considered. And so I think there was a desire to make certain that there wasn't confusion. But as of this moment, there is a disparity that some of the continuances or the extensions of deadlines are still in effect in the trial courts, some. And I don't want our colleagues to believe that everything is delayed until June, but some deadlines are extended in the trial courts. But to my knowledge, these continuances or extensions of deadlines have expired in relation to appellate practice.
What communications has the Court of Appeals had with other courts in our state, including the Supreme Court, Criminal Court of Appeals, and even the lower courts? Can you give us some insight into how decisions are being made and who's involved in them?
Well, we're certainly conferring with the others. I have visited with Chief Justice Bivens on a couple of occasions to make certain that I'm interpreting the Supreme Court rules correctly so that we can move cases forward without being inconsistent with or in conflict with the letter or spirit of their orders. Also, the Court of Appeals and Court of Criminal Appeals, our Chief Judge and even our presiding judge in the Western Section, Steve Stafford and Mike Sweeney, our Chief Judge, have conferred with John Everett Williams and others about how they want to approach things. Matter of fact, the order that I crafted that Judge Sweeney and Judge Stafford agreed with, saying that we're going to hear a certain number of cases by video conference, but the others will be assigned on brief. I got their concurrence first, and then the Court of Criminal Appeals asked if they could use our order, and it's my understanding that the order they've been using in the last couple of weeks is the same order or substantially similar to the one that we put out. So we are conferring with each other. Also, our staff attorney, Trey Owen, is very involved in the ABA, and he has had conferences with his committee across the country about what other appellate courts are doing. And it appears that our moving forward with video conference hearings is we are at the forefront. We're not the only one, but we are more progressive than some of the others. Whether that makes it right or wrong, better or worse, I don't know. But the U.S. Supreme Court has been doing it by telephone conference instead of video conference, and I think that's an effective way to do it as well. As much as I'm enjoying seeing and hearing from you right now, I believe you and I could have just as effective a communication by the telephone. And some people are in areas where their connectivity is simply not as good as in some of the municipalities. And we want everybody to have an equal opportunity to be heard.
Speaking of communications and equal opportunity to be heard, we have a question from an audience member about pro se appeals. Have you had any of those come up on your docket during this time? And have you seen any issues with dealing with pro se litigants?
We certainly have some pro se appeals throughout the year, and we have some that are ready to be set now. When I decided which cases we would hear by video conference, I endeavored, with the assistance of my staff attorney, to identify the cases that might have some more sophisticated nuances or issues where the panel might be more interested in or in need of questioning the attorneys to, as I say, split the hairs or to see the forest for the trees in the nuances of their argument. As of this moment, I have not set for video conference any cases involving a pro se litigant. That doesn't mean that I won't, and we have ruled in favor of pro se litigants before who were opposed, whose adversary was represented by an attorney. And so we take their cases very seriously, and they win on occasion. In fairness, as you know, you've got a better chances of succeeding if you have a skilled advocate representing you. It's kind of like, I'm not going to treat myself. I'm not a medical doctor, so if I need help, I'm calling in the professionals.
I've learned the hard way myself that you should always call a plumber if you have a water or plumbing problem.
True.
I have another question from an audience member about how time is being kept for oral argument when you're doing these hearings via WebEx or Zoom, maybe.
we have the timer set up so that it appears at the bottom of the screen. As you know, whoever is talking, usually the camera is activated to the person who is talking, and anybody else who is involved in the hearing, there'll be a little box with their, where you can see their face. Well, one of those little boxes is the timer. And so it appears there, but always encourage the attorneys to say you are welcome to use your cell phone if you want to keep time yourself. And I do so as well if I'm the presiding judge. The other day, the timer, as I was looking at it, the connectivity on the camera on the timer froze. And so it wasn't ticking down. And so I knew that that was wrong. So I politely interrupted the lawyer and said, please forgive me, but the timer isn't moving. And so please don't rely on that. And you've got 3.5 minutes left or something. But the timing hasn't been a problem, but we do have a camera on the timer, but also having a member of the panel having the cell phone timer and the attorney himself or herself, it's advisable.
Are there any changes that you think will become permanent changes even once, hopefully at some point, we're out of the woods on this pandemic?
Well, I think the video conference oral arguments may make sense in the future, especially for those people who have to travel long distances and incur a great expense of airfare or lodging or what have you. If the argument can be conducted by video conference in an effective fashion, I'm open to doing that on maybe not a full-time basis, but a more frequent basis. Also, if a member of our panel, for example, when there has been at least one occasion when I was to sit in Knoxville with my colleagues on the Court of Appeals, and a snowstorm, it started snowing like crazy on Monday afternoon when I was going to drive up for the Tuesday and Wednesday docket. And I was sitting there nervously worried about, do I drive up there and waste my time if they close court on Tuesday or what have you? It wound up being that court was closed the next day, but we were able to figure that out on Monday afternoon and Monday evening, so I didn't drive up. Had it been by video conference, we could have still held court, heard the cases. And so there's some reasons that video conferences may be with us in the future. But I still like seeing and hearing people in the courtroom, and you can appreciate their personalities a little bit better and vibes. And so I still like the in-person touch, but I'm very open to video conference oral arguments.
Is there anything that lawyers can do to help matters move more efficiently in the appellate courts during this time?
Write good briefs, write clear and concise motions that are supported by affidavits and a memorandum of law. My advice would be the same today as it would have been last year, and that is do your job well, be thorough. Don't believe that the longer brief is the better brief. Don't use 2 words when 1 will do. Make your point. Other than just be the good, practice the way a good lawyer would in a non-pandemic will go a long way in a pandemic. Of course, having the proper technology is important too. And that may be a key that I should talk about, and that is make sure that your law practice has the appropriate technology to allow you to communicate with the appellate court clerk, to do e-filing if need be, to have video conferences. And if you're in a location with poor connectivity, make arrangements for you to participate in the video conference from somewhere that has a better connectivity, better internet service.
I want to invite members of our audience, again, if you have any other questions for Judge Clement, if you'll go ahead and submit those across as we are coming close to the end of our time with the judge today. Judge Clement, have there been any silver linings from your perspective from this situation, or is there anything in particular that you've been grateful for during this time?
Well, I think a lot of people have been willing to be flexible, to understand that we are in a serious time and some deadlines must be extended. Yet, if we can move forward and hear cases, then let's try to get the right technology and bring ourselves up to speed on how to do it. And in fairness, some of the lawyers, and I'll say judges too, have been a little nervous about when they first did the video conferencing. And some of us needed more help than others on, now, how do I download the Zoom app or the WebEx app? Or how do I sign in for this hearing? But we have found people have said, well, if I need to learn something new, I'm going to learn something new. And we've made progress, but there have been times where I remember last week we had to delay the start of our oral argument by 10 minutes because Mr. Hibner was trying to walk one of the attorneys through. Now, okay, why don't you sign off and start all over again? And then one of the lawyers had signed in twice because he didn't get it right the first time, but didn't sign out and then tried to sign in the second time. So there have been some little bumps in the road, but the panel, we just said, this is fine. Just a few minutes delay and we'll just go with the flow.
Can you give us any insider information or make any predictions about whether we'll see another order similar to the ones that we've already seen from the Tennessee Supreme Court?
I do not have any insider information, but I do think the key going forward will be similar to what the Supreme Court has been doing for the last few weeks, and that is asking each judicial district to submit a proposal on how each district will reopen their courts. And the Supreme Court has been approving each of them independently over the last couple of weeks. And I believe that's a key going forward is how are we, I'm going to use this term with all proper intent, how are we going to herd grasshoppers? You know, to be safe, and because some people are more concerned with the consequences of the virus than others. And if someone has a health concern, or I hear them talking about, well, anybody who's over 60 is in a dangerous category. Well, I'm 70, and so I'm not worried about it, but I'm practicing safe distancing, and I wear a mask when I go outside in public, and so I would not want to be asked to get in an elevator with 15 people. I would not want to go to a general sessions courtroom where it's packed. And so the judges, we have a duty to be respectful of legitimate concerns that people have and of the very practical scientific factors that this is a virus and viruses spread. They jump from one person to the other, and you don't have to touch that person to get the virus. And so we have to be mindful of that.
Judge Clement, do you have any parting thoughts you would like to share with our audience members before we bring the town hall to a close?
Well, just realize that you are a professional and you should be prepared and competent in whatever capacity you're working. And if you're an expert in the family law or in contract law or in transactions or personal injury, you may need to become also competent in technology, in video conferencing, in teleconferencing, in the ability to send filings via email, e-filing. And so you might need to develop some new skills in the cyber technology. And I've learned one of the best ways to do that is to ask a young person for help.
Judge Clement, thank you so much for being with us today and sharing your time and all of this valuable information and insight with our members.
Well, thank you, Laura, and for everything you and the Nashville Bar do for our legal community.
And we will now bring this town hall to a close. Thank you everyone for being with us today.